Hello and a warm welcome to the EDRM Global Webinar Channel. My name is Mary Mack. I'm the CEO and Chief Legal Technologist for EDRM. Today's webinar is an EDRM collaboration with our trusted partner, eDiscovery Today. We're now in our sixth season. It's called Most Important eDiscovery Case Law Decisions for September 2025. Our faculty experts are Doug Austin, Tom O'Connor, the Honorable Judge Andrew Peck, and myself. We welcome your questions and feedback on the council. Questions will be answered both during and at the end of the webinar. And this webinar will be available for replay at your convenience for the next quarter, as are all of our EDRM webinars. Slides will be available after the webinar. Holly Robinson, EDRM's Senior Marketing Operations Manager, is here. Holly, can you please tell us what resources are available? And I don't hear you. Well, I'll tell you then. So if you take a look at the console at the bottom of your screen, you'll see the question mark icon. And this is where you can type in questions for today's faculty. And we'd love to hear from you. So please send in the questions anytime. The paperclip icon is where you'll find resources that we have gathered for you. It includes a downloadable guide to On24's engagement tools, a link to subscribe to eDiscovery Today blog, an excellent way to stay informed every day at eDiscoverytoday.com, a link to learn more about the Honorable Judge Peck and how you can engage with him. And then you'll also see registration for next month's case law webinar, Important eDiscovery Case Law Decisions for October, happening on October 20th. And we'd love to have you join us again. And don't miss what's coming up next on EDRM's webinar channel on September 11th. Join Brett Burney and the eDiscovery construction experts for 5 unique challenges in eDiscovery for construction litigation and how to solve them. Make sure to save your seat. And all of those are under the paperclip icon. And if you'd like to learn more about today's faculty, take a look at the speaker bios section. And just like Zoom, you'll find the smiley face emoji and other icons for sharing your reactions during the webinar. We highly encourage you to use them. Test them out now. And lastly, the Twitter bird icon is for social media. And you can follow both EDRM and eDiscovery Today on LinkedIn. Now for our faculty, we have the great Doug Austin. Doug Austin is the editor of eDiscovery Today, a daily blog about eDiscovery, information governance, cybersecurity, data privacy, artificial intelligence trends, best practices, and case law. Doug is an established eDiscovery thought leader with over 30 years of experience providing eDiscovery best practices, legal technology consulting, and technical project management services to commercial and government clients. Doug has published his daily blog since 2010 and has written numerous articles and white papers, receiving JD Super Reader's Choice Awards as a top eDiscovery author and top cybersecurity author. Tom O'Connor is the director of the Gulf Coast Legal Technology Center, affectionately known as TOMO. He is nationally known as a consultant, speaker, and writer in the area of computerized litigation support systems. Tom's consulting experience is primarily complex litigation matters, where he's worked with firms of all sizes, including the plaintiffs in the BP litigation. He's also been appointed as a technical consultant by various federal and state courts on cases dealing with large amounts of electronic evidence, and he hosts with Rocky Messing, the eDiscovery channel on YouTube. And the Honorable Judge Andrew Peck is a Band 1 Chambers ranked senior counsel at DLA Piper, serving 23 years as a United States Magistrate Judge for the Southern District of New York. Before his appointment to the bench, Judge Peck was in private practice for 17 years, focusing on commercial and entertainment litigation, including copyright and trademark matters, with extensive trial experience. And at DLA, Judge Peck advises on those copyright and trademark matters and also serves as a resource for the firm and its clients on litigation strategy and discovery issues, information governance, and cross-border discovery from a judge's perspective. And sought out as a conference speaker concerning eDiscovery issues, Judge Peck has been retained to serve as special eDiscovery counsel to clients and law firms and to submit expert reports on eDiscovery issues. EDRM is grateful to all three gentlemen for their service on the EDRM Global Advisory Council. And without further ado, Doug, do we have some cases?
We do indeed, Mary, and welcome everyone to the webinar on the work. We do have 6 unique cases to discuss this month, and those cases address disputes related to reopening of depositions after a belated production, forensic examination after discovery failures, production of source code and hyperlinked files, filing a corrected key spreadsheet, sanctions for deepfake videos and images, and possession, custody, and control of Slack data. Of course, we do welcome questions, and we'll try to get to as many as we can. And we'll send out a copy of the slides after the presentation, so look for that too. Of course, any ideas expressed by us here today are our own, not those of our organizations, clients, or partners. Disclaimers run deep, but are never fake. And here's a quick note about the webinar format and sources. This is the latest in a series of monthly webinars about case law, and the cases we discuss each month will be those covered on eDiscovery today. We provide links to each of the stories about the cases, which in turn have a link to the actual case ruling, where you can check out the full ruling itself. These case law rulings are available courtesy of Minerva 26, which is a great resource not only for case law, but also for federal and state rules, checklists and forms, and a glossary of legal and eDiscovery terms. Minerva 26 has nearly 44,000 lifetime federal and state case law rulings, and they add as many as several hundred cases a month. Minerva 26 is the definitive source for eDiscovery case law out there. So with that said, let's get into the cases. In our first case, which was suggested by Judge Peck and covered by Michael Berman on the EDRM blog, plaintiffs filed a motion to reopen 3 depositions of defendants' employees in light of defendants' belated production of documents that defendants had previously designated as privileged. As California Magistrate Judge Lisa Cisneros stated, there is no dispute that defendants withdrew their privilege designations as to the vast majority of documents in dispute and produced those documents after the witnesses at issue were deposed. Defendants also failed initially to provide a privilege log as required by Rule 26b-5 of the Federal Rules of Civil Procedure. And of the relatively small number of documents for which the parties were not able to resolve their privilege disputes, this court has found that most of those also are not privileged, at least not in their entirety, and should have been produced, at least with redaction. Continuing, she noted, defendants dispute whether the documents at issue include sufficient relevant information not previously known to plaintiffs to warrant reopening the depositions of these particular employees. But where defendants have brought this situation on themselves by withholding documents from production without sufficient cause, the court is not inclined to second-guess plaintiffs' assessment of the potential relevance of the document. Under Rule 30 of the Federal Rules of Civil Procedure, the court must allow additional time for depositions consistent with Rule 26b-1 and 2 if needed to fairly examine the deponent, or if the deponent, another person, or any other circumstance impedes or delays the examination. Defendants impeded these examinations by failing to produce documents subject to discovery prior to the deposition. The court is inclined to grant plaintiffs the opportunity they were previously denied to question the witnesses about those documents, at least some of which relate specifically to each of these witnesses. However, she also noted this order is intended to redress defendants' previous failure to produce documents, not to grant plaintiffs a complete do-over of previous depositions. To that end, the reopened depositions shall be limited to questions pertaining to documents produced after the original deposition, questions pertaining to testimony from other witnesses' reopened depositions, and reasonable follow-up questions to the witnesses' responses to those questions. Plaintiff's failure to abide by those limits shall not be grounds to instruct the witness not to answer or suspend a deposition, but after the deposition has concluded, defendants may seek any relief that they believe appropriate for a substantial violation of this order, potentially including the exclusion of evidence or attorney's fees for wasted time. So, Tom, do you think that waiting to withdraw privilege designations on documents until after depositions could have been a strategic move on defendants' part?
You know, that thought crossed my mind when I first read the case, but upon a second reading, I'm struggling to see what the strategy was. I mean, was this
Right.
was this the legal version of the Harlem Globetrotters hide the basketball under the jersey? Like, we'll put it here and they won't notice, and then as soon as the depots are over, we're going to take the ball out and pass it to somebody, and nobody will notice that that's what happened. I don't get it, especially when coupled with, as you just read, they didn't produce a privileged log. Like, we're not going to do the documents because they're privileged, and we're not going to give you a log, so we're not going to talk about it. So I don't know. As the court explained, in fairness demands that the other party gets a shot at this, and it's not a do-over.
Right.
Just to address these specifics. So if it was a strategy, it failed miserably. But it looks kind of like, I mean, I guess I'll just say quickly, what interested me is I didn't see the judge use the word bad faith anywhere. So, so am I getting the sense that there's a feeling of just ineptness, like they just, didn't get it right? And so the judge is going, yeah, all right. Yeah, you missed the deadline. The motion is late, but fairness demands that they get a shot at this. So go ahead.
Yeah, couldn't agree more. So Judge Peck, since Tom brought it up, given that defendants also failed initially to provide a privilege log, should privilege be waived on any remaining documents they still identified as privileged after the redesignations?
I mean, I see them as two different issues. At least as I read the decision, the chronology is not exactly clear, but it sounds like they initially didn't produce a log, and then they were forced to do a log, and then I suspect they had over-designated, very, very broadly. Oh, an attorney was, around the corner, so we're going to call the document privileged. The over-designation of privilege, then they were challenged on that. I mean, again, I got the feeling that they went and produced what they did produce that they previously withheld, not out of the goodness of their heart, but because they had been challenged on it and were forced to do so. So, the question then is what's left and why? I mean, there can be legitimate close calls so that if they reviewed the ones they did review because they were specifically challenged and the plaintiff didn't challenge the remaining documents, that would be one thing. One can look at some documents that are very close calls and, Monday decide it's privileged, Tuesday decide it's not privileged, Wednesday decide it needs to be redacted, whatever it may be. So, I think we would need to know more about why these documents that remain indeed remained. And it sounds to a certain extent like they were not challenged, but who knows?
Right. Yeah. And it didn't sound like there were many left anyway, based on what Judge Cisneros said. So Mary, what advice do you have for our audience to maximize the advantage gained through additional deposition time without violating the restrictions set by Judge Cisneros?
Well, I think this is a situation where the judge has given an inch, and so it's probably best not to take a mile in a situation like this. Maybe a foot, but so I'd suggest a Tiger team to take a look at the document that, the corpus of documents that give the green light for additional questions, and then develop those deposition questions, and then have somebody who's not involved in the case listen to make sure that you haven't overstepped, because this isn't, the judge has pretty much put people on warning not to violate 1.1 in this case, where, the judge would get particularly angry. The other thing I'd say is that these days we've got advanced technology for depositions. And so I would use them, use the AI, have the AI help in this issue. or in this situation. Systems like cloud courts and others that are attached to existing platforms would really serve the team well.
Yeah, absolutely. And yes, I think we have a couple of cases that might be Rule 1.1 cases. Certainly we'll talk about those. And I would say that this next case probably qualifies as one of them. It was also suggested by Judge Peck, where Nevada Magistrate Judge Nancy Coppey referenced a contentious discovery process and also referenced a ruling from nearly 3 years ago where that involved the umpteenth discovery dispute brief for judicial resolution. And mind you, that was 3 years ago. Recently, Mentos filed 2 different motions for a forensic examination or to compel, one in April 2024 and one in October 2024. In each case, the court denied the motion without prejudice. The first time, ordering CIMIC to undertake a thorough search for responsive documents, and the second time ordering CIMIC to produce the responsive documents in native format and provide a supplemental declaration detailing his search efforts. When issues persisted, Mentos filed a third motion for a forensic examination or to compel. Judge Coppey considered 3 issues regarding potential discovery misconduct. The first one dealt with a single document related to meeting notes. And despite the fact that CIMIC was required to produce the documents in native form, including metadata, one of those documents was a PDF version of notes of a meeting with FTX, which was created the day it was produced. Judge Coppey noted what is even more problematic, Mentos provides evidentiary support showing that CIMIC 0004 had been altered. Mentos contended that the PDF of CIMIC 0004 that CIMIC produced had been altered for litigation advantage. CIMIC violated the court's order to produce the native version of CIMIC 0004, and CIMIC violated that order as a bad faith tactic to avoid confirmation of his evidence manipulation. She also noted these types of substantiated accusations of bad faith discovery violations should be the stuff of nightmares for any attorney. And yet, the response to the pending motion ignores the issue, providing no rebuttal or argument of any kind. There continue to be misstatements and confusion in the eventual production of a file in Word format while they had stated the original was in Apple Notes format. Ultimately, Judge Coppey explicitly stated, given the repeated misrepresentations, the court has no confidence in the accuracy of the current representations made as to the document at issue, including whether the actual native version of these notes has truly been produced. CIMIC also failed to provide sufficient detail in his sworn declarations regarding his search for responsive documents on his text messages, laptop, and Microsoft Teams account, despite being ordered twice to do so, and focused his search on only a few months when the request called for multiple years. Given these factors, Judge Coppey concluded Mentos has made a strong showing of discovery misconduct. Summed up in legal technology, a terminology pertinent to this motion, CIMIC has displayed many different types of behavior that warrant a forensic examination, including failures by the responding party to produce requested information, serious questions about the reliability or completeness of the materials produced, serious questions about the candor of the producing party's assertions, and foot dragging of the responding party. She also found that lesser remedies are not feasible in this case. So Judge Coppey adopted Mentos's proposed protocol for the forensic examination. So Judge Peck, would you have given CIMIC as many chances as Judge Coppey did before ordering a forensic examination? And would you have considered ordering sanctions given CIMIC's repeated misrepresentations?
Well, clearly this is a Rule 1.1 violation case. And for those who may not remember from month to month what Rule 1.1 is, it is the unwritten rule that says, don't piss off the judge. Clearly, all of these violations, including, ignoring apparently court orders, is not going to be well received. But the question, and I don't recall the answer, I don't think it's revealed in the case, but who is paying for this forensic examination? I mean, often a party will say, we so much need a forensic exam that we are willing to pay for it in the first instance. and we'll worry about trying to get reimbursed by a later court order. I don't know what the situation was here. If any of you remember something in the decision that I missed, let me know. But, I certainly suggest at this point, it should be CIMIC that is paying the costs of the forensic exam, not Mintus.
Absolutely. Yeah, I'm checking on that. I think it was CIMIC that was ordered to pay for it, but I'm not entirely sure. But I'll be looking it up while I ask Mary this next question. So Mary, if Mintos hadn't requested and the court required CIMIC to produce the documents in native format, it might have been more difficult to confirm that the FTX meeting notes may have been altered. Why do you think more parties don't request native production, especially given how easy it is to manipulate images?
Well, first, they don't know they can request the native files. They don't read your blog, Craig Ball's blog, Tom's blog. They don't read anybody's blogs. And the other reason is that they may not want to produce their own documents natively. So, what's good for the goose is good for the gander. The expense and time of processing and review of native files once you receive them. But here in this case, there's a difficult file format, and that's Apple Notes. And so I dug into that a little bit, and it does want you to export it to PDF. Apple's documentation says, in short, the native format of Apple Notes is a closed, database-driven system, and its content is only truly accessible within the Apple Notes ecosystem. To use your notes elsewhere, you must export them into a more universal format, resulting in a PDF with a create date the day it was produced. So I think this was a competence issue, and but I guess that's Tom's question on competence. So I will leave it at that.
Okay, interesting, Mary, because I did not know that much about the Apple Notes format, and so that does shed some interesting light on it. And I also will mention, I did look it up, and there is a statement in the court ruling that says the selected examiner will be retained at CIMIC's expense. So yes, Judge Copy did make CIMIC pay for it, which makes sense. So Tom, about competence, what do you make of the behavior of CIMIC's counsel in this case, and the comment by Judge Copy that that at best she feigns incompetence through the declaration?
Well, that's a telling statement. Is she incompetent, or is she playing fast and loose with the court? For the judge to say at best she feigns incompetence. Is she being disingenuous with the court? And I'm mindful of two other things that were said. I think you mentioned both of these. CIMIC violated an order as a bad faith tactic to avoid confirmation of evidence manipulation, which would seem to lie at the feet not just of the client but counsel. But further, at some point, the counsel maintained that no native format document existed for this particular document. This is from the report on the case, and suggested the client might be withholding it, and then finally offered to produce it, only to show that it was created the day before the case was initiated and after the version that was produced by CASA. There's a lot of stuff that here that I don't know if it's incompetence or if it's skating on the edge of I will say at best being disingenuous. It's never really clear to me from what I've read in the case. Certainly the judge states point blank on several times that the client is dragging their feet, and the question is the attorney complicit in that? I just can't tell. Yeah.
No, it's fair. I mean, it's really difficult to do justice to that whole discussion about this particular document, which is very detailed in the ruling, and really goes through a lot of twists and turns. So yeah, it is interesting, especially in light of what Mary said as to whether this is truly, kind of being, deliberate misrepresentations or just actual, incompetence. A note here by Sheila Grilla: the nature of natives is very misunderstood by many people, and I couldn't agree more. Native files, have their different challenges and how you produce them, especially, a file format that's not standard. You might encounter some challenges. So we'll move on to our next case, which Kelly Twigger discussed in the EDRM webinar we conducted on hyperlink files last month. And as you can tell by the luxurious font size on this one, there wasn't a lot of discussion on these two issues. Here, the parties disputed whether the plaintiffs are entitled to the source code for Salesforce Chat. Chat, which is an API, is configured by customers like Rite Aid and Kaiser, who control the data. The plaintiffs argued that the source code would reveal how Chat routes communications and Salesforce uses the data. Salesforce countered that Chat's functionality, not its code, was relevant. It provided discovery about its software and software architecture and capabilities, and the plaintiffs sent their Rule 30b-6 topics, which will illuminate the issues. Salesforce also contended that disclosing proprietary source code risks competitive harm in Salesforce software as a service market. California Magistrate Judge Laurel Beeler stated, "On this record, discovery is disproportionate. Salesforce documents and proposed depositions offer less burdensome alternatives to understanding Chat's functionality. The plaintiff cites cases where source code was disclosed, but all involve the voluntary production of source code. Courts authorize alternatives like documents, diagrams, and testimony as less burdensome, proportional alternatives to source code disclosure." However, Judge Beeler also stated, regarding hyperlinked documents, Salesforce need not produce publicly available material, but must disclose all relevant chat-related hyperlink material about functionality and architecture. The plaintiffs must specify any disputed hyperlinks, and the parties must meet and confer to resolve disputes per the court's standing order. So, Mary, we've seen plenty of cases where discovery of source code was allowed under a protective order. Are you surprised that Judge Beeler chose not to do so here?
Well, with Salesforce opposing it's not a slam dunk, and the proportionality argument Salesforce made was compelling, and they offered an alternative. They offered the functional requirements and documents, and that was what was deemed to be relevant. So I think courts pretty much don't want to give up source code unless there's a darn good reason or the parties agree.
Yeah, certainly we're seeing cases involving the potential of source code discovery on the rise, but certainly doesn't mean, like you say, doesn't mean a slam dunk that it will be produced. So, Tom, are you surprised that Judge Beeler provided no analysis regarding production of relevant chat-related hyperlink material, given how so many cases have discussed the burden and difficulty of doing so?
I thought it showed an excellent judicial temperament by Judge Beeler. In the words of that great old blues song, she didn't want to make her move too soon, right? Like, right. Why open that can of worms now? And to that point, she ordered Salesforce to, quote, disclose all relevant chat-related hyperlink material about functionality and architecture, end quote. And then she ordered them and said the parties must meet and confer to resolve any disputes. So it sounds to me like the judge is well aware that there's going to be some argument about this, but no sense jumping into that at this stage of the game. Maybe they'll settle all those disputes at a meet and confer, and they won't have to get into that argument. But best to maybe kick that can down the road a little bit here.
Yeah, fair point. Yeah, why get into it until the parties raise it? So
right.
Certainly. So Judge Peck, what could the plaintiffs have done, if anything, to make a more compelling argument to compel Salesforce to produce the source code?
Probably nothing. Courts take very seriously protection protection of source code. Often where it is agreed to or ordered produced, it's produced via a standalone computer, not linked to the internet in any way. The expert can take some notes, but can't screenshot anything, et cetera, et cetera. So to a certain extent, at this point, all plaintiff can do is see if the Salesforce documents in the deposition testimony on chat functionality do or do not provide the necessary information. If they do, that should be the end of it. If they don't, you have to make a very good record as to what is missing, what you don't know, et cetera, and come back to the court on it. But probably not going to get you anywhere.
Yeah, probably not. But yeah, absolutely. It'll be interesting to see if either of these issues come back in further rulings, and we'll leave it at that and move on to our next case. And we've already discussed one case that can show how important a single document can be in discovery. Here's another. In this case, involving a dispute over a drop in commissions paid that led to the termination of plaintiff, defendants electronically searched their invoices and produced an Excel spreadsheet that purported to provide the details of all invoices for plaintiff's territories from 2015 through 2020, which contained a whopping more than 276,000 entries. Defendants subsequently also produced 12 boxes of information relating to the sales made in the relevant time period. Yes, I did just say boxes. After plaintiff produced his expert report to defendants discovered that the original spreadsheet was over-inclusive, containing 1,068 entries that involved invoices outside of plaintiff's territories or for products not sold by defendants. After defendant reported the error, plaintiff's counsel responded that he would not issue a new expert report based on a corrected spreadsheet because doing so would be unduly burdensome and prejudicial to plaintiff. Still, defendants produced what they purported to be a corrected version of the original spreadsheet with 1,069 entries removed, which is 0.004% of the total entries from the original spreadsheet, which led to plaintiff's motion to bar the corrected spreadsheet. Noting that plaintiff does not identify any of the removed entries in the spreadsheet that he claims should have remained, New Jersey Magistrate Judge Ruxana Singh stated, because defendants could have discovered the errors before expert discovery began, the court finds that the supplementation was not timely made here. She also noted, considering the complexity of the nature of the businesses as well as the numerosity of invoices that had been filtered to create the original spreadsheet, the confusion is understandable. It is reasonable that defendants' closer analysis of the spreadsheet first arose in preparing for the expert's deposition. Under these circumstances, the court finds that while defendants could have been more diligent sooner, the confusion within the original spreadsheet is objectively reasonable. As such, defendants' failure to timely supplement their discovery with the corrected spreadsheet in this instance is substantially justified. While Judge Singh noted that she need not consider whether the failure is harmless under the various applicable factors, she did so anyway, noting that plaintiff could have deposed the individual who created the original spreadsheet. Plaintiff did not detail the cost, time, or efforts associated with the preparation and service of any amended expert report. Reviewing the changes may not be a big deal because defendants provided plaintiff with a spreadsheet of the removed items, and since expert discovery had not closed, there wasn't a significant disruption to expert discovery. In denying plaintiff's motion, she also noted that there is no indication that defendants' untimely supplementation through the production of the corrected spreadsheet was done in bad faith or willfully. So Judge Singh pointed to the fact that plaintiff did not depose the individual who created the original spreadsheet, and he did not detail the cost, time, or efforts associated with the preparation and service of any amended expert report based on the corrected spreadsheet. Did the plaintiff drop the ball here?
Well, I think technically, perhaps. I mean, the court made it clear the motion was late, and at the same time seemed to be, if not bending over backwards, certainly making it clear that the judge wanted the information to be admitted. I mean, stating that it was, the plaintiffs had said that they objected to it, but they didn't give any analysis of, what this alleged cost, time, or efforts would be to deal with the corrected spreadsheet. So yeah, all right, maybe they should have, but then the judge went out of the way to say, we're only dealing with 0.004% of the total entries from the original spreadsheet. And quote, a review of the changes may not be a significant undertaking, end quote. So did they technically drop the ball by not stating that? Yeah, and I'm not sure the judge wasn't going to let that motion and that corrected spreadsheet to get in anyways.
Yeah, agreed. So, Judge Peck, how much does the case calendar impact judicial decisions like this? For example, if expert discovery had closed, would you have considered a different ruling than the one Judge Singh issued here?
The case calendar is very significant, and it also depends on local either rules or customs as to whether the magistrate judge can modify a case calendar that the district judge originally set. I mean, technically, a magistrate judge can't overrule a district judge. It goes the other way around. But there are lots of districts where the magistrate judge and district judge work very closely together, and the magistrate judge has either explicit or implicit authority to change the schedule. Or if one can't officially change it, you call up the district judge or walk down the hall and say, here's the situation. You need to modify your scheduling order because. Some district judges may not care about any other deadline, but would not be very happy about changing the trial date, either by the magistrate judge changing it or asking the district judge to change it, or indeed having the parties ask the district judge to change it. So yeah, that, where you are in the calendar here, the expert period had not expired, which makes it easy. The one other point I would make, I'm a little suspicious here that the reason that the plaintiff did not do a new expert report or did not say what would have to be done and how expensive it would be is because it was probably, the expert had done a spreadsheet and, push a few buttons and remove the 1,000+ entries, and it would not have taken any time or much money to do it. Yeah. That is perhaps why plaintiff went with the, it's not fair, we're not doing it. And, unfortunately, that result didn't work.
No, it did not. And yes, if you don't have really a good case to make, I guess you try a vague argument and see if it will go anywhere, and it didn't. So that makes sense. So, Mary, the defendants produced 12 boxes of information relating to the plaintiff's sales. Why would the plaintiff have not insisted on an electronic production of that evidence?
Well, they didn't seem interested in those invoices, the originals of them. They seemed to prefer the compilation, which in my view would be a cost or a competence issue. But the hard copy invoices, we do still get paper in eDiscovery, and it is, as it was stored in the usual course of business. So making that argument may not have been something that was important to them.
Yeah, I guess so. Although you would think that maybe they could have at least said, well, we'll scan them and produce images, but who knows? Just definitely, I don't know how often people are still getting paper productions, but it definitely certainly stood out to me. So interesting, but we'll move on to the next case. And as you can see, it comes with visuals. We added it last minute, as we just found out about it last week. Hat tip to both Judge Scott Schlegel Louisiana, Judge Scott Slagle, and Michael Berman, who both covered it. In the case, the plaintiffs moved for summary judgment in March 2025. In support of that, plaintiffs provided several documents exhibits. As California State Superior Court Judge Victoria Kolakowski stated, upon review, the court suspected plaintiffs' exhibits 3, 6A, 6B, 6C, 7, 21, 27, 35, and 40 of having been altered or created by generative artificial intelligence. For instance, exhibits 6A, 6C, and 36 purport to capture the speech and image of Jerry Haas. But while exhibit 36 appears to capture a real-life interaction, certain characteristics of exhibits 6A and 6C, such as the lack of facial expressions, the looping video feed, among other things, suggested that these exhibits were product of Gen AI, i.e. deepfakes. Judge Kolakowski provided several examples of deepfake videos and images in her order, a couple of which are on these next couple of slides. For example, the court finds that exhibits 6A and 6C are products of Gen AI and do not capture the actual speech and image of Jerry Haas. In other words, these exhibits are deepfakes. Here's a screenshot of exhibit 6A, which is the screenshot you see on the right. She also provided links to the actual videos and noted that the court has downloaded a copy of exhibit 6A to preserve the evidence. Comparing videos 6A and 6C to exhibit 36, which was deemed to be legitimate, Judge Kolakowski said, while the person depicted in exhibit 6A and 6C bears a passing resemblance to the person depicted in exhibit 36, they are not the same person. The accent, cadence, volume, word choice, pauses, gestures, and facial expression, among other characteristics of the person depicted in exhibit 36, are vastly different from those demonstrated by the persons depicted in exhibits 6A and 6C. She also discussed examples of deepfaked images, including the one you see on the screen here, saying, the lighting, contrast, color, and sharpness of the man depicted in these pictures compared with the lighting, contrast, color, and sharpness of the background shows that the man was stitched into the photograph taken by the Ring camera. A close inspection shows that the background is in black and white while the man is in color. Oops. She also found that exhibits 35 and 40, purporting to be Instagram and iPhone group chats, respectively, are products of Gen AI, or at least were materially altered, and identified several other suspected deepfakes, which she did not have the time, funding, or technical expertise to investigate. She also noted how the metadata belied plaintiff's statements, noting that Apple Intelligence isn't available on the iPhone 6. Noting that after her show cause order, plaintiffs did not appear at the hearing and were not excused from appearing, she stated, as the contesting party was not present, the court affirms its tentative ruling and issues a terminating sanction against plaintiffs for intentionally submitting false evidence to the court in connection with their motion for summary judgment. She also declined to refer the matter for criminal prosecution or issue monetary sanctions. So, Judge Peck, if you were in Judge Kolakowski's position, would you have referred the case for criminal prosecution, or did you feel she was right not to do so?
No, I don't think I would have. First of all, let's remember the plaintiffs, the Mendones, are pro se here, and that is a different standard, not legally, but that's just how it works. You expect more possible improper conduct by pro ses who don't have counsel. I'm also not sure, although my days of doing criminal duty have been 7 years in the past, but I don't know that the deepfake constitutes either perjury or a forgery in the usual sense, a forged check, a forged signature, whatever it may be. Without dismissing the case, it wouldn't have been enough to go to the criminal authorities. And with dismissing the case, it might be overkill, may also depend on how busy The DA's office is in that jurisdiction. I suspect in the Southern District of New York, if we were to refer this to the U.S. Attorney's Office, at least the old U.S. Attorney's Office, they've got better things to do than deal with a little bit of mischief here. I think that the judge did the right thing here.
Yeah. I mean, understandable for sure, and certainly very interesting. So, Mary, what can courts do, if anything, to minimize the risk of parties submitting deep-faked evidence like the pro se plaintiffs did in this case?
Well, I think pro se litigants submit evidence that usually is not collected to our normal forensically correct standards, and they might have metadata that's a bit askew, and that seems to get admitted anyway. As Judge Peck said, there's a little different standard for the pro se, but I think there could be some education with every pro se form about not altering digital evidence without disclosing. I mean, certainly if you want to enhance a picture, if you let people know that you've enhanced the picture, that's one thing. But if you just go ahead and do it, and then you materially change things, that's just not fair. So we've had campaigns around malware, clicking on phishing emails. Don't copy that floppy for those of us of a certain vintage. I think there needs to be some form of educational campaign for people using the court system without attorneys.
Yeah, absolutely. And we've needed that for pretty much ever. So, yeah, absolutely. I also kind of wonder if, because this obviously in this case, these deep fakes were not very good. They were easy to spot. But as we know, they're getting better and better. So chances are we're going to have cases where they could be pretty hard to spot. So I know when I covered this case last week and put it on LinkedIn, somebody talked about or referenced the C2PA standard, which basically provides an open standard for publishers to essentially, kind of establish, the transparency and authenticity of the content that's being generated. And I don't know if we, might get to a point where we need to see some standards like those kind of take off and have, some traction there. But certainly I think this is the first, it's not the first of many, but it's certainly, I would think we would see many more deep fake video or deep fake evidence type cases like this one here. So Tom, speaking of another case with fabricated evidence, we covered the Rossbach case a few years ago. And in that case, the plaintiff submitted a fabricated text message exchange as evidence. And in there, the court not only issued terminating sanctions, but also monetary sanctions against both the plaintiff and her counsel, though the counsel monetary sanctions were subsequently vacated by the Second Circuit. Should Judge Kolakowski have issued monetary sanctions to deter other pro se parties from doing the same thing that they did here?
Well, a couple of points. I mean, doesn't a terminating sanction do that just as well, if not better? Two, as everybody's pointed out, we've got pro se appearances here. The judge may have felt that monetary sanctions weren't going to do anything because maybe they didn't have enough money to make that, a worthwhile effort. And as far as deterring other pro se, well, I'm not sure pro se litigants have a formal or informal bar association where they get together and talk about these things. Right. Trial attorneys tend to get together and talk about cases at the local coffee shop or at bar association meetings. I'm not sure that there's communication amongst pro se parties that in the same manner. Third point, remember the Rossbach case was a federal case, and the sanctions were thrown out because the district court hadn't made an express finding of bad faith, which was necessary for those sanctions to be imposed. I don't know what the standard is here in California. The judge didn't address it specifically, talked about the criminal sanctions, but not monetary sanctions. But the judge went on at great length in her opinion to talk about the problems facing courts and dealing with Gen AI and problems that are going to come up. Something that Judge Schlegel down here in the New Orleans area has also talked about a lot. He's become the local expert on Gen AI and deepfakes in particular. The thing that struck me most in the order was the statement that, quote, without robust safeguards to guard against future misuses of the legal proceedings, an evidentiary or issue sanction is effectively toothless, end quote. So I don't think the judge felt that sanctions were going to do anything here. We need to get at this particular type of evidence with a little bit more scrutiny.
Yeah, absolutely. Yeah, I mean, could have argued that the court was out. There was money wasted and all the time invested in this, but certainly I could see it either way. So interesting case, and I wouldn't be surprised that we see more deepfake related cases coming up.
Oh yeah.
Yeah, for sure. So our last case is one from earlier this year that was covered by Kelly Twigger, and as Tom would say, is a bit of a head scratcher. It's an employment discrimination case where the plaintiff alleged sex and race discrimination and retaliation, where Texas District Judge David Godbee ruled on several motion to compel responses from both plaintiff and defendants in this ruling. Two of those related to plaintiff's request for responsive documents from Slack and Chatter to employee communication platforms used by defendants. In ruling on Slack communications, Judge Godbee stated, regarding the Slack communications, defendants explained that they do not have possession, custody, or control of documents from Slack because Spirion's Slack license never included message retrieval or exportation, and Spirion did not otherwise store or archive Slack messages. Because the Slack documents are not in defendant's possession, custody, or control, the court denies Vaughn's motion to compel the Slack documents. And to paraphrase Forrest Gump, that's all he had to say about that. As for Chatter communications, Judge Godbee stated, defendants argue that these communications are not relevant because sales employees, not IT employees, use Chatter, so Vaughn, her comparator, and her supervisors did not use the platform. However, Vaughn produced a declaration of a former Spirion sales employee, Chris Costancio, in which he stated that Jim Cronenberger, a Spirion sales executive, had discriminated against Vaughn, including by making bigoted, sexist, and homophobic comments about her. Accordingly, there could be statements made by Cronenberger on Chatter that are relevant to Vaughn's claims. The court thus grants her motion to compel production of documents from Chatter involving Cronenberger that are responsive to requests for productions numbers 9 and 10, and to compel a supplemental response to interrogatory number 14. So, Mary, do you buy the argument that defendants don't have possession, custody, or control of documents from Slack because their license doesn't include message retrieval or exportation capabilities?
Well, it's certainly not a question of technical impossibility. It's a license limitation, so that's money. And if you look deeper into the Slack documentation, there's a note there that says workspace owners should be able to run their own export in order to comply with an appropriate legal request. If you need assistance with those exports, the primary owner can contact us to see if they qualify for an export due to legal necessity. So I don't think so. I mean, they're using Slack. The messages are there. There's got to be a way to get them out.
Yeah, absolutely. And exactly right on point, Mary. A couple of people, when I covered this case, pointed out to me that, Slack has enabled the full corporate export functionality for a limited time if you contact them and demonstrate a legal or investigative need. So certainly the ability does exist. And obviously that wasn't dealt with. So Tom, should the plaintiff have pushed back more on defendant's assertion that they didn't have possession, custody, or control of documents from Slack, or even anticipated this objection so that they could refute it?
Yeah, I would have pushed a little bit more here because it's unclear to me, as Mary just pointed out, the Slack license itself provides a functionality to get those if you request it. But the timeline here is the plaintiff used Slack while employed at Spirion. Then the plaintiff was let go. And it's unclear to me then, did Solera purchase or acquire the Slack licenses for all employees? And even if they did, what about an ex-employee? Were in fact those messages and or whatever device or devices that employee was using prior to the acquisition and prior to being let go, where were they? Were they still at the company? Did Solera get those? Seems to me there's a question here about what data is in their possession simply from the acquisition of the information when they bought the first company, when they bought Spirion. And it doesn't, that's not clear in the pleadings, at least what I read. It's unclear. There's got to be something somewhere deeper down if we dove into some of the motions.
Right.
But yeah, if I were the plaintiff, I would have pushed it.
Right. Well, and unfortunately, yeah, great point. Yeah, because Spirion was acquired by Solera, and I mean, let's face it. Right here on the slide is everything that was said about the Slack discussion. So,
yeah,
unfortunately, the court just didn't get into very much detail about what the acquisition impact or what they could and couldn't do or anything. It was just a simple couple of sentences, as you see here. So we could have certainly used more. On discussion on that issue for sure. So Judge Peck, what's a judge's role in a dispute over possession, custody, or control? Should they expect the party claiming that they don't have it to provide details about why they don't have it, or should they just take a party at their word unless the other party objects?
Well, neither. But we are in an adversarial system. So if Solera says, sorry, Judge, we can't do it. We don't have PCC of the Slack messages, and counsel for Vaughn doesn't say anything in response, then that's what the record is before the court. Now, if the court had a similar case against Slack before, the court might have known more, but otherwise, it's up to the parties, and the parties could have, particularly the plaintiff, as Mary and Tom were suggesting, gone through Slack's public documentation about what can and can't be done, and how they will help you if needed, etc. A more interesting question might be, if you were dealing with a platform unlike Slack that didn't give you that extra ability for legal purposes, but you could have bought, the next level, instead of the free Slack license, you could have got the premium one, or whatever they call the one that lets you get stuff. What would the cost of doing that be? Would that cost be proportional to the needs of the case, et cetera, et cetera? So it can raise some interesting issues. And then, of course, the other factor is Vaughn could have issued a non-party subpoena to Slack and said, we need this. They may have been faced with, well, it's not our data, it's Solera's, et cetera, but in terms of another way of getting at the data, or, could have the court could have, at plaintiff's request, ordered Solera to issue a subpoena to Slack to get around any of the issues about the Stored Communications Act. So there are other things plaintiff could and should have done. They didn't, and therefore the court was left with, somebody saying, I don't have it, and the other side isn't saying anything against that. So that's the end of that discussion.
Yeah, indeed. And I think this is a good case that shows the importance of understanding the technical aspects if you're the requesting party and understand what, a party should and shouldn't be able to do in terms of production. I mean, we've had that discussion with hyperlink files, and certainly, this is another example of that. So yeah, very interesting and interesting and a case that I think we can learn from. So now on to the contacts page, and we do have a date for our next webinar, which is just 3 weeks away on Monday, October 20th. Thankfully, Judge Peck's already sent me several cases, so I think we're in good shape. Looks like we'll be all manic all the time this fall, as not only next month's webinar will be on a Monday, but November's will as well. So with that, I will say thanks to Mary, Tom, and Judge Peck as always, and I'll turn it back over to you, Mary, to close us out.
Thanks, Doug. And we thank you and Tom O'Connor and the Honorable Judge Peck for this insightful presentation. Our thanks to the EDRM community for your kind attention. And we'll see you next time on the EDRM Global Webinar channel. Thank you.
Thanks, everybody.
Bye-bye.
Bye all.